So this panel is called The Legal Outlook for Climate and Energy Rules. Some of you may have noticed we had a new president take office about 8 months ago. And since January, President Trump's administration has dramatically reshaped the regulatory landscape for climate and energy policy, beginning the process of rolling back major Biden-era rules that reduce greenhouse gas emissions and promote clean energy, while at the same time taking immediate actions that boost fossil fuel production and hamper solar and wind, as some of the prior panels have talked about today. In this panel, we'll explore how these moves are transforming the prospects for environmental protection, the pace and tactics of rollback efforts, and the shifting legal landscape as courts and agencies respond to novel strategies and doctrines. And we'll really try to unpack the hurdles that are facing climate and energy rules in the courts, consider trends in judicial responses, including at the Supreme Court level, and discuss the outlook for the Trump administration's climate and energy agenda and deregulatory agenda, ultimately. So we have 4 incredible experts on this panel, who I will introduce in alphabetical order. So we have Kirti Datla, who's the Director of Strategic Legal Advocacy at Earthjustice, whose work has shaped many debates over environmental law and agency authority over the years. Prior to joining Earthjustice, Kirti clerked on the Supreme Court. She worked as an attorney in the Office of Legal Counsel at the Department of Justice. She worked in private practice in the Appellate group of Hogan Lovells. Kirti is a graduate of this law school. It's wonderful to have you back here today, Kirti. I feel like I've been on several of your panels this year. You've spoken in my class. Now you're on this panel, so I look forward to speaking with you again today. To my left, we have Sanjay Narayan, who's the managing attorney and chief appellate counsel for the Sierra Club, and who's an expert on climate and environmental law and litigation. Sanjay joined the Sierra Club in 2002 after stints at Earthjustice in private practice and clerking, and in his current role, he plays he has a leading voice in Sierra Club's strategic decisions involving clean air, clean water, and other major policy issues. And Sanjay, you two, despite us living on opposite coasts, I feel like I've seen you many times this year, but that doesn't make it any less sweet to see you again today, so it's wonderful to have you today. On the far end, we have Ilya Somin, a professor of law at George Mason University and the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. Ilya is a renowned, nationally recognized scholar for his expertise on executive power, constitutional law, property law, democratic theory, federalism, migrant rights, and many others. I could go on. He's a frequent contributor to the Volokh Conspiracy. Conspiracy came up, and Politics blog, and his original work has appeared in many other places. Ilya, it's an honor to have you here today. And finally, last but certainly not least, is Allison Zeev, the litigation group director at Public Citizen and a leading voice on regulatory litigation. Allison has directed Public Citizen's litigation efforts since 2009. In that role, her litigation practice focuses on public health, consumer safety, open government, and many other issues. She's argued before the Supreme Court on numerous occasions, and she's taught courses at Georgetown, American Law, and Yale Law School. Allison, it is an honor. There's an old adage in poker that says if you look around a table and you can't figure out who the easy money is, it's probably you. So I think the easy money at this table is me, looking around here. So it's really just an honor to be with all 4 of you today. So let's jump right into it. We'll start by kind of talking about what the Trump administration has been doing. We'll talk about how courts have been reacting, and then we'll try to project forward for how courts may respond in the future. So, when President Trump prepared to take office late last year, he vowed to undo the climate and energy rules from the President Biden and Obama administrations, and to eliminate regulations on business kind of across the government. So we're now, as of a few days ago, 1/6 of the way through this term. We only have 83% of the way to go. So let's talk about how is he doing so far, and where is this administration in its deregulatory efforts. So Kirti, I'll start with you. So what are some of the most important climate and energy rules that this administration has proposed and begun the process of rolling back? And can you discuss some of those?
Sure. So I'll mention a couple, and everyone's going to have their own interpretation of importance, but these I think illustrate both the centrality of climate and also some of the different tactics that the administration is pursuing in its deregulatory effort. So obviously the most obvious thing to talk about is the endangerment finding and the associated standards that are keyed off of it. And so I probably don't need to tell the folks in this room, but just in case, the endangerment finding from 2009 concluded that greenhouse gas emissions endanger public health and welfare and was associated with a set of emission standards for vehicles that were keyed off of that finding. All of that is dependent on, or at least associated with, a Supreme Court decision in Massachusetts versus EPA. So the Trump administration has proposed rolling back the endangerment finding, and it has offered a bunch of different rationales for doing so, some of which I think will be explored a little bit more on this panel. So first and foremost, it has reinterpreted the Clean Air Act to say that air pollution covered by the Clean Air Act is air pollution that has local or regional effects from the emissions, as opposed to, for example, global emissions. It has also invoked the major questions doctrine, which I know we're going to talk about a little bit later today, as a reason why the prior interpretation behind the endangerment finding is, in its view, unlawful. And then there's just sort of beyond that, a grab bag of different rationales relating to, for example, arguing that the science that was underlying the 2009 finding, it was incorrect, relying on a new report put out by the Department of Energy to bolster a different view of the science, and, for example, arguing that the endangerment finding and associated standards are unlawful because they didn't adequately take into account the benefits of climate change. So the comment period on the endangerment finding just passed, and then the agency is proceeding, for now under the sort of normal processes for rolling back a regulation, which I think will allow us to talk a little bit later about, what obstacles those normal processes present for some of its actions. Another set of things that the agency is targeting are energy efficiency standards issued by the Department of Energy. And some of these garnered headlines because they're funny in some sense of that word. So the president, for example, directed the Department of Energy to repeal energy efficiency standards for shower heads. And this is also unusual because of the direct presidential involvement and the sort of direct nature of that action, so not going through notice and comment through the agency. The Department of Energy has also proposed going through the sort of standard processes for repealing a bunch of other energy efficiency standards that are in place right now that resemble the more traditional process. And then I'll just say one more reg that maybe folks don't intuitively think about, but there is public lands rule from the Biden administration that governs how federal agencies think about the use and disbursement of federal lands, and that rule elevated conservation considerations to have them sort of weigh within considerations of, for example, whether oil and gas can be extracted on public lands, and the administration has proposed repealing that rule as well.
Sanjay, would you like to talk about any others?
Sure, although, as Kirti said, the hardest thing here is most important, because there's a lot, and what you think is important probably varies. But I do think there are a couple other categories maybe emphasize this administration's real focus on fossil fuels. The administration has proposed to repeal a suite of regulations on power plants promulgated by the Biden administration. The biggest is a proposal to withdraw all greenhouse gas regulation of power plants. That's probably partially subsumed by the endangerment finding, but they've set that up as an independent rule based on the idea that power plants don't significantly contribute to climate change, and that this matters for regulation as sort of a necessary prerequisite. They've also proposed withdrawing the mercury and air toxic standards update for power plants and wastewater discharge standard for power plants, which are not necessarily important to the entire fleet, but have important regional and plant-specific applications. So altogether, sort of a comprehensive withdrawal of the Biden administration sort of power plant suite. The other thing I'll mention is just the methane regulations for the oil and gas sector. This was a set of resource performance standards that governed extraction and mostly transportation of oil and gas. They weren't especially hard for industry to meet, I think, but they did achieve significant reductions, both quantitatively and because methane is a particularly potent greenhouse gas. So, and there, I think the thing that's interesting is that they did that via first an interim final rule, that is one without notice and comment, that purported to change the compliance deadline. So this is a feature of sort of moving without a lot of administrative process that you might expect for this sort of thing. And then they're following that up with a potentially, they've said, a formal withdrawal rule.
Great, thanks Sanjay. I've kind of, as a law student in practice for many years, I've come to think that regulation or deregulation can take years, and yet here we are 8 months into this administration, and it seems like kind of most of the big rules in the space are already very much in the crosshairs, if not proposed or in some cases already repealed. Sanjay, can you kind of talk quickly about kind of how this administration compares to prior administrations in terms of both the timing and the scope of their actions?
So in terms of timing, they're moving really fast. If you look at the big set of greenhouse gas rules during the first Trump administration, right, the power plant and vehicle rules, the proposals arrived, I think, between 9 and 18 months into the administration. And then the final rules came towards the middle of 2019 to the beginning of 2020. So 2.5 to 3 years in, which I think is pretty consistent with what we've seen across administrations. This time, for the most part, the proposals have all arrived already, so within the first 6 months of the administration, 6 to 7 months. And they're saying that they're going to get them done by the end of the year. Those final rules will come out by the end of the year, which would be very fast. But even if that slips a bit, right, they're still shaving a year or two off what we think of as a standard timeline. And they're doing that while, for the most part, proposing rules that are much broader in scope than those that we saw the first time around, right? If you look at the vehicle rules during the first Trump administration, they left Massachusetts versus EPA alone, but did seek to essentially gut one set of vehicle standards that was sort of forward-looking. Whereas now, the idea is that they're going to simply make them all go away, and they're going to do that to sort of essentially a sweeping, well, there's a lot to it, but the primary rationale would be a reinterpretation of a law that would, in my view, run pretty much right against Massachusetts versus EPA, but they want to test that.
Right, so they're basically trying to prevent the agency from regulating kind of ever again in that space.
It's like a compromise. So it's sort of move fast, but also break much bigger things, I think, seems to be that.
Yeah. Allison, you've highlighted a bunch in the past how kind of in addition to kind of what we think of as standard rulemaking processes, this administration is also using various litigation tactics to undo agency rules from prior administrations. Can you briefly discuss some of these efforts and what you're seeing here?
Well, a bunch of the rules that Biden issued were in court because every significant rule and many insignificant rules that he issued were immediately challenged over the past 4 years. So many of them were in court in January 2025. And some of those no longer are because the administration has just caved, or in the case of, for example, the SEC's climate rule, the rule about disclosing the climate impacts of your work in your SEC filings. That case was pending in a court of appeals in the 8th Circuit, and it's just been currently stayed, presumably so the SEC can withdraw the rule, which didn't go into effect because of the litigation. There's some other cases where the agencies, I'm not sure if EPA has done this or DOE, but there are several cases where other agencies have just folded in litigation. The FTC, for example, recently dropped 2 appeals challenging district court decisions that had held their rules were contrary to law, that they had no authority at all. So now those district court decisions will stand. The CFPB in a couple cases filed sort of consent motions asking the court to enter judgment against it, holding that it couldn't, a rule that it had issued was exceeded its authority or was an invalid interpretation of the statute. So they're taking advantage of existing litigation to try to get court rulings that will bind them and limit their own authority in the future. They're also, not through litigation, but avoiding notice and comment in a few cases by issuing rules that they issue as directly final as opposed to proposed rules. Kirti mentioned one, the rule about water efficiency for shower heads, because Trump issued an executive order saying rescind the rule about water efficiency for shower heads. The Secretary of the Department of Energy then issued a short notice saying we're rescinding it and we have no choice because the president told us to, and therefore we don't need to go through notice and comment rulemaking as required by statute. Another way we think they will take shortcuts is the president directed agencies, particularly EPA and DOE, to order that all existing rules would sunset after 5 years, which means many of them are now at 5 years. Major rules generally last a really long time and don't usually have a sunset. So we're waiting to see if they do that through one big notice per agency or whether they're going to do them individually. And then how to fight back about that in litigation would depend on whether they bundle them or not. Agencies announce in advance what their upcoming rulemakings are. It's a little unclear from the Office of Management and Budget's online regulatory agenda what some of the rules are, so we don't currently know if they're going to repeal rules without comment, repeal rules saying it's a 5-year sunset and the president ordered us to do it, or whether there'll be notices. But we have seen at least some rules on the OMB docket that indicate they're going to go directly to final when we've never seen a proposal. So we'll see what those are.
So it sounds like kind of across each of these spaces that you've talked about, this administration is moving very quickly. In some cases, they're cutting kind of procedural or substantive corners. When you said that's a fair characterization, is there anything you would add on that you're seeing?
Yeah, though they are smarter than the first time. The first time they sort of had a general idea about how administrative law worked, but not quite, and so they sort of thought they were complying, but they were messing it up, and it made it easier for us to challenge, and the agencies lost a ton of cases. They know more now, and they're being more clever. I think one reason they started with the shower head rule, other than that Trump is apparently obsessed with his hair, is that it's really hard to come up with anyone who has standing to challenge this ridiculous violation of the Administrative Procedure Act, because you can't just rescind a rule because the president said so, which is all the notice says. But who has standing? Because we actually all have shower heads that comply with the better standard, because that's the only thing that's sold in the United States. And in order for his rescission to have any effect, the manufacturers would have to start selling what I'll call non-compliant shower heads in the United States. So right now no one has standing. So because it was so stupid, the litigators all really wanted to challenge this thing. But I think they started with something like this, both because he's obsessed with his hair, but also because it would sort of set a precedent for them in a context that we couldn't challenge because of the lack of standing.
Gotcha. Speaking of moving kind of quickly, Ilya, I'll turn to you. You've written quite a bit in recent months about this administration's use of emergency powers in various places across the administrative state to take actions kind of quicker and more expansively than prior administrations have. Can you talk about where you're seeing that and some of the trends you're observing?
Sure. So the abuse of emergency powers is not an entirely new thing with this administration. There have been problems in a number of past administrations, including under Biden. But what we see with this administration is its use on a larger scale and in a sort of, in some ways, more clearly abusive way. There are several areas where this has been the case, but I'll just mention 3 big ones. One is with tariffs, where they've used the International Emergency Economic Powers Act to start the biggest trade war since the Great Depression. We have now the highest tariff schedule since that era, and if it continues, we will have harmful results comparable to what occurred in that era. That is now obviously under challenge. I'm actually co-counsel in one of the cases challenging it, which is now before the Supreme Court. We won in the trial court and in the federal circuit, and hopefully, we'll see what the federal Supreme Court does, with regard to that issue. But they're using there a statute which doesn't even mention tariffs, and even if it does allow authorization of tariffs to some degree, it says it can only be done with an unusual and extraordinary threat. The supposed unusual and extraordinary threat is trade deficits, which have existed for decades, and there's nothing unusual or extraordinary about them. They're probably not even really a threat at all, because basic economics says that there's nothing inherently harmful about trade deficits. We see a similar pattern with immigration, where the president has said that illegal migration and drug smuggling across borders qualifies as an invasion that enables him to shut down nearly all legal migration pathways across the southern border. And also, he has used it to invoke the Alien Enemies Act to send people to imprisonment in El Salvador. The Alien Enemies Act generally can only be invoked when there is a war, an invasion, or a so-called predatory incursion. It has previously been used only in the War of 1812, World War I, and World War II, very obviously actual wars, calling what is going on now an invasion. I don't think you need to be a legal scholar or whatnot to recognize that illegal migration and drug smuggling are not invasions in the way that what happened during World War II was, or the British burning Washington during the War of 1812, and so on. And here too, the Alien Enemies Act and also the Invasion Executive Order has generated litigation, which has so far, for the most part, gone against the administration, but the Supreme Court has yet to give any definitive ruling on this, though they have signaled in 2 or 3 cases, depending on how you count, that at least the issue of what is an invasion is actually judicially reviewable. A third big area is the use of the military domestically, which under various statutes can generally only be done if, yes, there's an invasion or there is a breakdown of civil orders on a large scale. And there, they use these types of statutes to federalize the National Guard in California, and for other types of actions there. The courts actually rejected a lot of their arguments, but the Ninth Circuit did hold that you have to defer to the president on the issue of, do the kind of conditions where there is a sufficiently serious breakdown of civil order exist. So in each of these areas, there's ongoing litigation. We'll see, obviously, what the end of it is. But I think, the bottom line, to my mind, is that whether there is a genuine emergency, as with the energy emergency, or with tariffs, immigration, these other issues, is an issue that should not go on the say-so of one man. It's an objective fact whether an emergency or an invasion or an unusual extraordinary threat exists. And I think courts should not be deferential on that, because the whole point of these emergency powers is that they should only be usable in extreme circumstances, not whenever there's a basically normal policy issue that the president otherwise can't get his way on. And the normalization of emergency powers is a very dangerous thing in terms of the harm that it can cause, both in terms of damaging people's livelihoods and civil liberties, but also in undermining the rule of law, because if massive changes in tariffs, immigration, the use of military, and other things can be done in one man's whim anytime he feels like it, that's pretty obviously the opposite of the rule of law. That's the rule of one man. There's also the energy emergency, under which less has been done than under some of these other ones. But there too, I think there's much value to increasing energy production, and having better and cleaner source of energy and so on. I'm very skeptical that there is a genuine emergency, given that energy production has actually gone up a lot in the last several years, and given that this too, like some of these other issues, a long-term ongoing problem, rather than what an actual emergency is, a sudden unexpected crisis. But I think the energy emergency is something that some of the other panelists probably know more about than I do.
Great, thanks, Ilya. So let's turn now to the energy emergency. As Ilya referenced, on his first day in office, President Trump declared that there was a national energy emergency, alleging that there's an energy shortfall, and calling on agencies to invoke whatever authorities that they have to boost national energy production in the short term, notably wind and solar were kind of exempt from this, and in many ways the administration has done the opposite for them. So Sanjay, I'll start with you, and then maybe we'll turn to Kirti. Can you kind of discuss some of the ways that agencies have been invoking their authorities in response to this executive order?
Yeah, so there are a few. I think the big one is the Department of Energy's invocation of its own emergency powers under Section 202C of the Federal Power Act. It doesn't involve the president, right? The Department of Energy makes this finding, which I think subtracts some of the issues that are in play in the other emergency cases. But yeah, this is a provision that allows the Department of Energy to compel generation in the event of war or an emergency. And typically, since World War II, it has been used to address kind of natural disasters, right? Floods, hurricanes, where you have a particular need for some sort of generation to kind of keep the lights on. What the administration has started doing is to use that power and the claim of emergency to override state and utility decisions to shut down fossil fuel-fired power plants. This has happened once in Michigan and once in Pennsylvania, but they've promised they're going to do it sort of on a nationwide basis. And the idea is that, as we heard earlier, they're expecting more demand, and so states and utilities, the emergency is that the states and utilities are not building enough of the right kind of generation, the right kind being fossil fuel-fired generation. And where they seem to be headed is a kind of a 5-year plan in which the Department of Energy sort of decides how much electricity the country needs, and then at some level picks the plants that are going to provide it, with the assumption being that the plants that will be picked will be mostly 75 to 80-year-old coal plants, which I think are actually not the cheapest and fastest way of getting that power onto the grid. So that's a vision. That would be a pretty transformative change in the way that the country has handled resource adequacy, and one that I think would be quite expensive. That is in court now, and I think it's going to be, the litigation is messy because it's a series of 90-day orders. So that's one. There are a couple other places where it's coming up. Notably, the emergency declaration is being used to either bypass or shorten administrative procedures, like notice and comment for mostly Clean Water Act permits for pipelines and so forth, for sort of infrastructure. And then there's a narrow band in which, not so much emergency, but national security, which is closely related, is being invoked to suspend or to delay the compliance timeframe for air toxic standards. But that last bit is just under one portion of the Clean Air Act, and it is, I'd say, not nearly as extensive as the other ones.
Kirti, do you want to discuss the Revolution Wind came up kind of briefly in the fireside chat this morning, but can you discuss that a little further and how this administration is kind of taking immediate actions to clamp down on wind and perhaps solar energy?
Sure. Yeah, just briefly, I think it's not an example of the energy emergency as sort of like a statutory precondition to exercising statutory authority, but it is, I guess, like if you think atmospherically that there is an energy emergency, then one response would be to respond to it in any and all way possible. And I think, I guess, the Revolution Wind story is an example of that. So the administration issued a stop work order against the completion or the construction of the Revolution Wind project off of Rhode Island. And the letter, which is like a page and a half, says that the administration is looking into national security related concerns with the project, and basically, I'm not leaving anything out. That's basically what it says. The project proponent took the administration to court and just received a preliminary injunction. There isn't a written opinion, but the bench, from the bench, the ruling seems to have been like, okay, like, what does that mean? Give us some details. And if you don't give us any details, given that there was a thorough study of the project before its initial approval, you can't just kind of say the words national security and get your way. So that's just a preliminary injunction. I suspect the administration will try and back up the statement in its stop work order, and the litigation will keep going. But I think that's sort of an example of the atmospherics of the administration's use of emergencies, national security concerns, other areas where the president typically has a lot of authority to direct the administration without, or with, I guess, maybe a little bit less judicial review on the back end to try and advance its policy objectives.
Great. Thanks, Kirti. I'll start with this question kind of for anyone who wants to answer it. You know, we've talked about kind of all these different things that the Trump administration is doing. We could surely throw out many, many more. You know, before we get to how courts are, judicial trends and what we're seeing in the courts, are there any kind of trends you're seeing across these different agency actions that you think are particularly notable or worth pointing out here?
So, I mean, obviously there's different agencies doing different things, but I do think the claims of sort of sweeping emergency powers based on things which are not actually emergencies, and then claiming that the executive has virtually unreviewable discretion in all these areas, that's not completely new to this administration. We've seen some things like this in previous administrations, but they're doing it on a larger scale, and it's extremely dangerous if allowed to continue, especially once you recognize that it might be one thing to say if we really believe we really just need a massive effort to increase the amount of energy production, but in reality what you see is, you know, an internal contradiction. On the one hand, they say we really need more energy. On the other hand, we got to shut down those wind power projects, and also they have massive tariffs, which, as the last panel explained, actually impede energy productions. Their immigration policies will also impede energy production over time because immigrants disproportionately participate in the construction workforce, which is needed to produce new energy plants and the like, among other things. And with new H-1B policy, which I think is also illegal, I've written about that a couple days ago, that will impede energy production and scientific development because immigrant H-1B workers are crucial to many of the scientific advances and breakthroughs that also enable us to get more energy. So this is not some kind of coherent effort to increase the amount of energy. This is really a kind of sort of right-wing nationalist culture war, xenophobic project, which sort of says certain kinds of energy sources, fossil fuels that sort of are right-coded are good, other ones which may be left-coded in their minds at least, like wind power, are bad, and especially bad is anything that comes from immigrants or foreign imports and the like. So the ideology here is internally contradictory, it's harmful and dangerous, and it concentrates a lot of power in ways which is dangerous. Though I would note that there's some irony in that when I used to say things like this in prior administrations, like with the student loan forgiveness under Biden, that was also a kind of pretextual emergency powers, pretextual use of emergency powers, there would be people who would say, we should let that happen. The president should exercise discretion, and we got to leave it to the experts in the executive branch. Now, sort of the ideological valence of these kinds of things has shifted somewhat, but I think the more general lesson should be that we do not want one man or a small group of people to have this kind of sweeping power over our economy. We should instead, where possible, let diversity and competition flourish.
Okay, thanks, Ilya.
I'll just add a short comment to your question. Pre-litigation, one thing we are saying is that because the president is impatient and largely ignorant of the details of regulation and the particular topics that he's impatient about. And so what the agencies are doing is, which is helpful to us when we get to litigation, is there's often not adequate reasoning or any reasoning. There's a lot of the president's same sort of rhetoric that you'd see in his Truth Social posts that are now also in a gazillion executive orders. You see those in the agency Federal Register notices, just sort of bizarre things that, to the extent the agencies are supposed to act with reasoned decision-making, we see a lot less of that in the rulemaking papers now than we used to.
Great, thanks, Allison. So what I seem to be hearing is that this administration is acting very quickly, it's acting very boldly, and in some cases, at least, it's acting somewhat sloppily. I'm going to read the CLE code right now. Some of you can probably guess what it is, or at least have one of three guesses. Our CLE code is Bronx, BRONX. I think I think, yeah, Staten Island and Queens really are getting the short shrift today. So maybe they could write letters to us. Bronx, B-R-O-N-X. Okay, so let's turn to we've talked about the Trump administration. Let's talk about the courts now. So this administration's regulatory actions have already been the subject of dozens of lawsuits, primarily and including in the areas of personnel, grants, and some of the regulatory actions that Ilya discussed, like immigration, tariffs. And courts, according to Just Security's litigation tracker, which I'll put in a plug for, courts have now blocked over 100 actions from the Trump administration, although some of these have been reinstated by higher courts, including the Supreme Court. And a lot of the major climate and energy regulations that Sanjay and Kirti started by talking about haven't been finalized yet and haven't been litigated. So Allison, I'll turn to you first. So kind of what trends are you seeing in these various court opinions that have been issued over the past few months? What kinds of issues is this administration generally winning? And what kinds of issues is it generally losing?
So as Max mentioned, there's been a lot of litigation about grant termination, en masse terminations of whole programs. There's been a lot of litigation about mass firings, and both of those relate to the litigation about and the fact that the administration is shutting down whole agencies or programs within the agencies. There was also a bunch of litigation early on about DOJ invading everyone's privacy. The courts have basically said that's okay, so if you thought you had privacy, you don't. In that litigation, the first thing we noticed was that the district courts were all, I just said this to somebody, we're all super sympathetic, like, this is really troubling, and I don't really know what's going on, and trying to push the government lawyers to give them more information, but the government lawyers really had no idea what was going on either, and the judges were annoyed about that and threatening to let us have broad discovery, and then they would issue decisions saying that we lacked standing because they didn't know what was going on, so we couldn't prove we were getting injured. So those cases, some of them still exist, but they're not going to be impactful, even the one we still have pending. So other than those, the cases have had a lot of success, as Max indicated, in the district court. The shutdown cases, the grant cases in particular, and many of the cases about mass reductions in force. The courts of appeals have gone both ways, and then the Supreme Court has basically shot the legal basis for the cases out from under us at every turn. So we are, many of those cases are still going on, but we're sort of looking to try to figure out what the Supreme Court is actually trying to say, because their decisions have been largely very brief. It has allowed litigants to come up with arguments about why their case is different from the one where the Supreme Court said that you could sue about grant termination or you can't sue about mass firings or shutting down an entire agency. But then Justice Gorsuch got very upset about that, about people making distinctions among different cases when the Supreme Court hadn't actually provided any reasoning for its brief decision in one particular case. So I guess the short answer to the question is we're doing really well in district court, but the outlook is not favorable.
Allison, I'll stay on you for one follow-up question. So as the law students and the lawyers in this room know, there's kind of this doctrine that agency action can be held to be arbitrary and capricious if it's poorly reasoned or logic or there's not a lot of explanation. And there have been a number of district court opinions kind of outside primarily the environmental space on this, such as on temporary protected status or housing of transgender inmates. There was a case on transgender status on passports. Kirti mentioned the one about Revolution Wind. So kind of what, are you seeing any trends in those types of cases that have gone more against the administration, or kind of what are you seeing there?
So in the district courts, there's been plenty of cases holding that their actions are arbitrary and capricious, and I think that's because they are arbitrary and capricious. But in the courts of appeals, we've had some trouble, like although the CFPB announced and the president announced we're shutting down this agency created by statute, then the DC Circuit said, well, maybe there's no challengeable final agency action, even though the district court had written a 112-page decision delving into the evidence in detail. So again, we're doing pretty well in the district courts on that because so many of the actions are crazy, that is arbitrary and capricious. And many blatantly contrary to law, which is the last phrase in the Administrative Procedure Act after arbitrary and capricious and abuse of discretion. But we are, if the courts let it go that far, I don't think there have been district courts of appeals decisions that have found the finding that an action was arbitrary and capricious was not correct, although they have sometimes overturned those decisions on other grounds. But a finding that it's arbitrary and capricious is based on the administrative record. It's more factual, and so if they don't find some other hurdle like standing or something, then it's more likely to be upheld on appeal. And I think we'll continue to see cases like that for at least 3.5 more years.
Ilya, you mentioned kind of 3 areas earlier where this administration is taking big swings. You mentioned tariffs under IEPA, the International Economic Emergency Powers Act, the restrictions on immigration under the Alien Enemies Act, and the use of the military domestically. I know all 3 of these have been litigated in some form or fashion, and you've been quite involved in the tariff litigation. Can you describe how courts have been responding in these types of litigations and what trends you're seeing there?
So, I mean, I've mentioned sort of what's happening in those 3 areas already, that for the most part in the IEPA tariff cases, by and large, those that have been decided on the merits, the plaintiffs have won. We won the 12 states case, which is together with ours, has won, and also the learning resources case prevailed, and on somewhat different grounds in each case, though also on overlapping grounds. And now those 3 cases are all in the Supreme Court, and we'll see what happens there. On the Alien Enemies Act, with one exception, every court that has reached the issue of whether there actually is an invasion or a so-called predatory incursion has ruled that there isn't one, with the exception of one district court, which I can talk about in detail if people are interested, which said, well, there's not an invasion maybe, but there is a predatory incursion. There have been also one district court which said it's all a political question, and the president gets to decide whether there is an invasion. I think is badly wrong, but that's what they ruled. But multiple district courts have said there's no invasion, there's no predatory incursion. Now the U.S. Court of Appeals for the Fifth Circuit has ruled that as well, and the Supreme Court has twice held up Alien Enemies Act deportations on sort of due process grounds, but also in a previous decision, the JGG case, they said that the issues of legal interpretation of the Alien Enemies Act are subject to judicial interpretation, which at least strongly suggests the courts get to decide what is an invasion or war or predatory incursion, as opposed to merely the president announcing there is an invasion. We all have to bow down and say yes, one exists if he says it does. And I think that kind of principle is a very bad approach to any kind of emergency powers, because it would enable one person to exercise sweeping emergency authority whenever he feels like it, just by mouthing some words, which defeats the whole point of making this an emergency power that can only be invoked in extreme circumstances. I mentioned previously what's going on in California with the litigation or domestic use of the military, where there was a setback in the Ninth Circuit on factual deference, but there's now further litigation over whether the Posse Comitatus Act has been violated, which is the act which generally constrains the domestic use of the military for law enforcement. And there's been an initial trial court ruling against the administration. We'll see how that goes on appeal. There's obviously other kinds of emergency powers issues, but on the whole, I'm moderately optimistic in terms of what courts have done in these areas so far, but we don't yet have any kind of definitive resolution of these issues from the Supreme Court. We may learn something about this depending on how our tariff case gets resolved. If the Alien Enemies Act gets back to the Supreme Court, which it may very well do, we'll learn something there. But I think the bottom line in all of these issues, A, can courts interpret the meaning of these words like emergency, invasion, unusual and extraordinary threat? B, a little bit more complicated, do courts have to defer to the president's claims that certain facts exist? I think the answer here is no, because otherwise that's a backdoor to unlimited power, but obviously some people think the answer is yes. And then also, there might be, in some cases, special technical doctrines of procedural issues and the like that that might also arise.
Great. So let's circle kind of back toward where we started. So, Allison and Ilya have identified these different trends that we're seeing in litigation as courts begin to respond to the Trump administration. Kind of most of the big deregulatory actions in the climate and energy space are still to come, like a lot of the ones we discussed earlier, like the endangerment finding, the power plant rules, the vehicle rules. So, Sanjay, I'll start with you. Kind of to what extent do the trends that we're seeing in cases, and perhaps trends that we saw in cases under the Biden administration, provide insights into how courts may treat the big regulatory rollbacks that are coming in the near future?
So on the one hand, I think that the kinds of threshold issues that seem to be getting courts hung up in the reduction in force and funding cases, right? Is there agency action? Those shouldn't be a problem for the big deregulatory cases because the pathway to reviewing agency action is pretty clear. And to the extent that district courts are telling us that the underlying actions tend to be arbitrary and capricious, right? I think that is likely to continue to be true. So on that front, I think, maybe there's some reason for optimism, but you're not going to get any unqualified optimism from me up here today, I think. What worries me about those cases is that I think there is some chance that by the time we get to them, the administration may have won half or more of the battle, right? Because if they succeed in transforming the agencies or crippling them, what the statute actually means matters a lot less, right? If FERC is not an independent agency, what the Federal Power Act means is at the very least like radically different from the way we think about it today. And if EPA doesn't have the capacity to administer the Clean Air Act, and what the Clean Air Act requires matters a lot less. So I think there's some reason for optimism, but the big picture still remains pretty dire. Sorry.
One of us has to come up with something positive to say before we close.
Well, so let's put on our kind of legal nerd glasses for the moment if we haven't been doing that yet. So, in the past few years, there have been, several big decisions from the Supreme Court that have reshaped certain elements of administrative law. We had the Loper-Bright decision last year, which said that it's courts, not agencies, that have primacy in interpreting statutes. A couple years before that, there was the West Virginia decision that struck down the Clean Power Plan and introduced the major questions doctrine. So, Allison, I'll start with you. Kind of how do you see kind of those doctrines affecting litigation over Trump administration deregulatory policies? Is it possible that Loper-Bright or perhaps a major questions doctrine can be used kind of affirmatively to rein in on deregulation, or do you see those? Do you see these kind of judicial trends kind of all going one direction in terms of limiting the authority of agencies over businesses and limiting their authority over the environment and the climate?
So Loper Bright and West Virginia versus EPA are really cases that are bad for whoever's in the White House and good for whoever's unhappy with who's in the White House. So whereas when we had a pro-regulatory president, we were unhappy with West Virginia versus EPA, the opposite is true now. Both of those doctrines, the major questions doctrine and Chevron deference, are fair weather friends, and so it just depends like which side you're on of whatever action's being taken. So when the administration shifted, and I can't remember, was this an executive order or what sort of document the White House issued, directing that agencies like review their regs for compliance with Loper Bright and West Virginia versus EPA, that made no sense at all because both those cases are about standards for judicial review. You can't have a rule that violates the Chevron doctrine or that violates Loper Bright. But we have seen the administration mention those doctrines. For example, in the proposed rule rescinding the vehicle standards, they mention the major questions doctrine. But that is not really helpful to them at this point to say that the agency just vastly exceeded its authority by doing something that it had been doing for years and years and years. And it was sort of blessed in Massachusetts versus EPA. So I think that's our friend now, and to the extent that the agencies are going to try to do unusual things, then they don't get deference anymore. So we're on equal footing. They no longer get that thumb on the scale. And at least in some courts, they won't really get a presumption of regularity either, which is a sort of a usual part of litigating against the government. And to the extent they're doing things that are really far out there, the major questions doctrine supports the challenger. To the extent there's anything left of that doctrine after the demise of Chevron deference, that it will be more helpful to those challenging government action than to the government. Now, if the government in some future, maybe in 3.5 years, becomes more pro-regulatory, then that would shift, and the red state governors will be using Loper Bright and West Virginia versus EPA to challenge what the agencies are doing, just like we might do it now. But at least for now, it's our friend.
Actually, I can say something optimistic here, so maybe I'll jump in.
Great.
On Loper Bright in particular, the major environmental statutes, like the Clean Air Act and Clean Water Act, are, if you look at them, they're very ambitious and they're very capacious. And to the extent that Loper Bright requires courts to pay more attention to the structure and design of those statutes, that I think is actually likely to be pretty unhelpful to an administration that seems to be sort of pushing very hard against what the statutes actually say. So on that front, I think that might be helpful to us. I mean, there's maybe a more realistic side of where the courts stand and how they might view the gaps. But at least if you look at the statutes, that's only good for us, I think.
Right, and some of these regulations, what we're seeing in the proposals is the administration, as some of you discussed earlier, is not just kind of walking back, a standard from X level to Y level, but they're saying we as an agency don't have the authority to regulate in this area at all, right? Particularly, we've seen that in the climate space. So, Sanjay or anyone else who wants to address this, do you see Loper Bright as a potential cudgel that could be used against EPA or other agencies when they invoke, when they try to deliberately narrow their own authority?
I mean, I think it should be, right? I mean, Massachusetts versus EPA was a Chevron step 1 decision that basically found that the plain text as it was, went against EPA's interest in not, or desire not to regulate greenhouse gases. So I think it should be something we can use, right? The concern is always that with these hard statutory questions, I think all of us have a tendency to superimpose our own policy preferences onto those in the statute. And when the administration keeps citing local pride, I think what they might be thinking is that they view the courts as sharing their policy preferences, and it's sort of an invitation to indulge that preference. But, to the extent we were talking about the text and structure and maybe even the purpose of these statutes, again, I think that runs pretty sharply against virtually everything the administration is doing right now.
Right. And some of these really big deregulatory cases, like the endangerment, are perhaps likely to wind up before the Supreme Court ultimately.
Right.
Kirti, I'll turn it to Kirti, I'll turn it to you. So kind of where do you, I'll bring you into this conversation, kind of how do you ultimately see courts weighing in on some of these big deregulatory actions that are to come? And I'll throw in a question from the audience here that dovetails with that, which is how likely do you think the Supreme Court would hold, how likely do you think the current Supreme Court is to uphold the withdrawal of the endangerment finding that EPA is proposing?
So I think if you're asking somebody who works at a nonprofit environmental litigation firm whether the Trump administration's actions are lawful and will be upheld, you're only going to get one answer. And so I think I'm going to answer the question in a slightly different way, which is to say, if you step back and look at how this administration has broad regulatory or deregulatory, depending on your perspective, goals in the climate and energy space. And it's pursuing those goals in different ways that we've kind of laid out today. And I think one way to think about answering that question is to think about the administration's views on litigation risk. So, as somebody who used to work at the Department of Justice, one way to think of it is that the government should just, put forth its best view of the law and be really faithful to doing what is lawful, and you can have debates at the margins about what that means. Another way to think about litigation risk, which other actors in our system do, is sort of what is the actual litigation risk? What can you achieve at the end of the day with your actions being upheld? And even if you lose, are you tolerating that risk because losing still is a victory to you? So you can think of something like the Revolution Wind example, and I apologize to the economists on the prior panel who are probably going to think I'm butchering this, but one way to think about that is it doesn't really matter if they win at the end of the day because they're injecting uncertainty into a process where the corporations involved need certainty for planning and financing and things like that. With some of the emergency orders, you can think of the administration's goals the same way. And then you can think of things like the endangerment finding where, at least externally, one way to look at what they're doing and the amount of effort that they're putting into it, even if they are moving fast, they're still proceeding through notice and comment. They're soliciting comments. I presume they'll respond to those comments. And they're offering a slew of rationales for the action, some of which seem expressly aimed to both the Supreme Court and all the lower courts that are going to review the action going up. So my instinct looking at it externally is that they're putting more effort into the things that they want to stick in the courts at the end of the day, and where that's less important, the stickiness of the action or the legality of the action or pronouncement about the legality of the action, they're not putting as many resources into that. And so, the question is always what the courts will do at the end of the day, and I can't really offer a prediction about that for the reasons that I said at the beginning. But I think that's sort of, if you're looking at I guess it's maybe a cautionary tale to be diligent in the way that you're looking about wins and losses and thinking about how to predict out whether future cases will be wins or losses based on what's happened in the past.
I'll just make a really quick comment. I don't think the question for any of these is whether it's what the action is lawful or unlawful based on the standards that we traditionally view as governing administrative law and agency practice. The question is just whether the Supreme Court will say it's okay. And those are different questions, more so than in the past.
Just briefly on sort of major questions and related issues, I write about quite a lot. Obviously, with I'm old enough to remember when Chevron deference in the 80s and 90s was something that conservatives liked and liberals generally didn't. Justice Scalia was a big fan of Chevron deference, whereas on the other hand, Justice Breyer wrote a famous article attacking it. And I thought that Breyer was right then, and I still think so now, because ultimately I think legal interpretation is the job of the courts, not the job of the executive branch, and also the executive branch has obvious reasons to be biased in favor of their own policy agenda and the like. And you can see it tell a similar story more recently with major questions, and also with the closely related issue of non-delegation, which I think the Supreme Court has resuscitated in its recent consumers research decision, which even though it upheld a delegation, it also clearly sent signals saying there are going to be real limits to delegation, like where they said big delegations require more precise standards than sort of narrow technical delegations. They said there have to be roofs and ceilings, I'm sorry, both floors and ceilings to how much power is delegated when it comes to imposing monetary fines and costs on people. And they even said that a ceiling of even if there is a hard ceiling, if it's too high, like if they said the FCC could collect up to $5 trillion in fees, that still would leave too much discretion in the hands of the executive. So that's a sign non-delegation will be an issue going forward. And it's absolutely true, I think, as Allison said, that in the short run, these doctrines benefit people who don't like what the White House is doing, and or harm those who do like it. So to some extent, where you stand on this depends on where you sit. But I do think there is a broader principle here, which is, do we want one man and his appointed underlings to have vast sweeping powers to shape and control the economy and society, or do we want to disperse that power more? And if your answer is we don't want one person to have that kind of power, both because maybe we don't trust the politicians, but also because it undermines the rule of law and stable expectations, then there's good reason to favor these sorts of doctrines, even if you don't always like the short-term consequences. Of course, it's easy for me to say that because I dislike most of the sweeping action taken both under this administration and also many of the ones under the prior one as well. So I didn't like the loan forgiveness, and I don't like the tariffs and immigration restrictions now. And so for people who do like some of these things and are more conventional sort of Democrats or Republicans, the trade-offs here are tougher. But still, I would ask, even if you think you trust Biden to spend $400 billion on loan forgiveness and you think that's good, there is still a question whether in general you want one person to have that much sweeping authority. And I think the answer should be no, both in sort of general policy terms, but also in terms of how our constitutional system is supposed to work, which is by dispersing power rather than, by concentrating it in the hands of, one person and the underlings he or she appoints.
Ilya, you are an equal opportunity dissenter.
It's easy to be that way when I don't like many of these underlying actions to begin with.
We'll turn to a few additional questions from the audience in the last 10 minutes here. So this one dovetails with a number of the things we've been talking about, but has a somewhat different flavor. So after Loper Bright in West Virginia, is there room left for a future administration to take ambitious climate action based on existing legislation, or is the only path forward through new legislation? And I guess I'll just add the kind of hiccup that we're not only thinking about this question now, but we're thinking about where this question may lead in several years. I don't know if anyone wants to take that. Sanjay, didn't you write an article about this last year?
No. I mean, new legislation would be helpful.
Well, let's take the first part of the question. After Loper Bright in West Virginia, is there room left for a future administration to take ambitious climate action?
Yeah, I mean, after Loper Bright in West Virginia, I think the answer is yes, and we saw it with the Biden administration, right? Like, there are pathways forward that existed as of a year ago. And I think, if we had a different electoral result, we would see those things, we would be on a more hopeful trajectory, right? The hard question, I think, is whether those pathways will still exist 3 years from now. And that one I don't have an answer for. I think it is certainly easy to imagine a world in which Congress needs to sort of return to the field more in a substantive way. Also, reasons to find it hard to imagine that outcome, right? But I don't. So for that future question, I don't have an answer, right? For the retrospective one, I think the Biden administration did like very good things and I think had a pathway to sort of, particularly through the IRA, of sort of moving things forward under what was the existing regime.
We got two questions that are sort of in the same vein on state rights and federalism. So one of the questions is, in the wake of current federal climate policies, states are currently serving as a bulwark for climate and energy resiliency. Has there been recent litigation over the federal reach or state power that kind of touch on state authority to kind of move the ball forward in the climate space as they did during the first Trump administration? And then relatedly, another question identifies that the president has directed the Attorney General to identify and stop state laws that impede domestic fossil fuel energy production, and where you kind of see that heading. So I guess I'll kind of put these questions together, which is basically, how much do you see the states taking ambitious climate action in the coming years, and how do you see the federal government and federal courts responding to that?
I guess one response is that it's true that state and local actors both have authorities they can use and are using them. I guess it's worth saying that it's also true that those who are opposed to progress on climate issues or energy issues understand that and are taking action to shrink that capacity. So you can think of examples like the local ordinances related to natural gas connections in buildings, gas stoves, that whole set of local action, and the Ninth Circuit decision holding that some of those are preempted by federal law. There are pipeline safety, there are sort of zoning regulations that affect pipeline siting that are sort of just traditional zoning regulations by localities, and there's a recent Eighth Circuit decision saying that is preempted. There are the affirmative actions by this administration's Department of Justice to challenge various state laws that are addressing climate, and so there's sort of like, it's sort of like whatever, the law of thermodynamics or something. When states and localities take action, there is going to be a reaction that attempts to use federal constitutional law to shrink that state capacity, and then those fights will happen in the federal courts.
There has been several cases that have been pending for years without getting very far, where some states or localities are trying to hold big oil companies responsible for the effects of climate change in their jurisdictions based on theories of nuisance or misrepresentation. Over the past, from 2021 through 2024, the administration did not try to block those, but there are preemption arguments that the big oil companies have made, and they file a lot of cert petitions trying to get the Supreme Court to take it, and there is one pending now where the Solicitor General proactively, without being asked to, filed a petition stage amicus brief telling the court that it was cert-worthy, unlike another case where they had said it wasn't. So I think there will be broad assertions in those cases and in other contexts of the court arguing that the state action is preempted, which is may or may not be right, but I think we're going to see a lot of broad assertions of preemption by the court by the agencies in all sorts of environmental contexts.
One more question from the audience. What tips do you have for advocates who are commenting on proposed regulatory rollbacks? What kind of issues are you looking for and teeing up for future court challenges?
Well, in litigation, any challenger can raise any issue that was raised during the comment period, whether or not the litigant raised the issue themselves. So any reasonable argument you have, put it in there with respect to the policy reasons, evidence why the agency's wrong or why the agency's action is unlawful. Put in cites to any studies that you've seen, and you can file the studies in the record as well. Certainly there's a lot more information put into the rulemaking dockets than one would later litigate about, but it's no harm in making 10 arguments about why something is wrong, even if in litigation you might only make 8, although I wouldn't argue things that you actually don't think are good arguments. As for law, though, like actually saying like this proposal is arbitrary and capricious, you don't need to make legal arguments. You don't need to cite Loper Bright or State Farm or any of the other cases about administrative law. The rulemaking docket is about facts, and so just put them all in there so the litigants can use them later.
Okay, I think that is a good place to end. Thank you all. This has been a really informative discussion.